24 আমাদের
এটা তো 23
না 24 ডাকলেন
24 ডাকলে 23 ডিসমিস
23 তে এই রিপোর্টটা লিখে দেবেন তো 24
yes my lord lordship on the last occasion your lordships your lordship were pleased to
substance allowance has been paid to the petitioner
at a time did by
এটা
Mr.
থেকে আছে pages 20 this
One instance, I'm seeking, I'm sorry, at this stage. This particular report,
এখনো দেয়নি প্লিজ আমাদের কপি দিয়েছে
the copy Miller that has been served, this is Miller still Miller, not in compliance of the direction passed by the Lordship's court. Now, Miller, this is a relentless violation. The copy Miller kindly sees, your Lordship's
paying for short pass over my lord. Report already come, my lord. Short pass over my lord. Please, my lord.
report already
Report already. Report, my lord.
is already there on record
My lord, directed for the
copy
report, my lord.
there was a
the
correction.
report
This
Yes.
your Lordship was not
In line with
satisfied.
my senior
With the
colleague,
earlier
my lord.
huh
Now
Kindly,
that
my
the
lord.
Lordship's pleasure was to direct Miller the authority to file a further report.
Yes,
Now,
my lord.
kindly appreciate Miller the precariousness of the copy Miller that has been served upon us. Kindly Miller takes pain to go through it, Miller, for a moment.
the school authority submitted arrear claim in favor of the petitioner for the period 12 to 14 on such and such and say have already been paid. School authority did not submit any claim beyond that period. Are you still there in sir? No, in
No, no.
18 you retired.
Miller, there was a conviction against, there was a conviction, order of conviction was passed against my client's husband. Miller, পাগল হয়ে গেছিস নাকি তোরা? Sorry. Now, Miller,
2018.
yes. Now, Miller, page 30 of your Lordship's brief, Miller, it indicates, Miller, what my prayer was. It is in no uncertain terms, Miller. I categorically stated, Miller, that is the period, Miller, for which I'm entitled to get the money. Number one. Number two, Miller, that the Provident Fund, the other parts, admissible dues, Miller, that is there. The board had conducted an inquiry. This inquiry, Miller, in no uncertain terms says, Miller, that the particular period for which, Miller, I was entitled to get the money, I did not receive. Now, even then, Miller, on the last occasion when the report was filed, Miller, it did not satisfy my lord judicious consigns. Then, Miller, my lord directed. Today, Miller, the government has come with a plea, Miller, that school has not forwarded. It was his duty to ask the school that whether, Miller, in securing compliance, that yes, this is the claim made by the petitioner. You tell me that whether there is any due bill is pending, which is due and payable to the petitioner or not. Miller, this is absolutely harassing in nature. I tell your lordship that this procrastination, Miller, is not by accident, Miller, but by design. Paragraph 4, your lordship's order kindly says. The last order.
Your claim is only with regard to the unpaid subsistence allowance?
Miller, my claim is a part claim, Miller. That is, Miller, 3. I question, Miller, the constitutionality of Rule 19 of the DCRB rule, which your lordship, Miller, initially was under impression that in respect of other case, Miller, where your lordship allowed the pension, Miller, but it does not lend any meaningful assistance in the present case. That is why, Miller, I stayed away, because your lordship was prima facie of the opinion. Now, today, Miller, I am saying that, but for an interim relief, in order to survive, Miller, so that the court that is why the court directed the authority that you come with a specific case that what is my claim and what is the admissible dues. Now, when the board had conducted an inquiry, if he finds that it is the school, Miller, the delay and negligence is attributable to school, then DI is well within its power, Miller, to
Right, let me see from the report. File your report.
Yes, ma'am.
Return this to the petitioner. From the report, it appears that no claim was raised by the school. Is it so? Give a copy of the report.
Yes, yes.
No, this is something else. The submission, give that. You have been served only with 2 pages.
No, I don't
Where
know.
are those 2 pages? Those pages are not
Yes, ma'am.
here.
I am supplying.
This was not given.
School authorities requested to submit necessary papers in connection.
Now, can you see the first annexure, my lord?
15th of December,
Yes, my lord.
TI requested the school.
Yes, my lord. Now, what is the reply of the school, my lord? Kindly see. Next page, my lord.
All
And-
these papers were not there with the petitioner. And there is a specific direction that it should be served prior to the next date.
My lord, that was, my lord, perhaps
Responsible
that was a mistake on my part, my lord.
Submitted such and such. Pranab Kumar Roy was absent from Atho to Atho as per before. You
Kindly,
say-
kindly see the reasons, paragraph, page below, that it, the letter dated 18/12/2025, 1 week before the intervocation, my lord. In response, it was addressed to the district inspector of schools. In response to your letter, VD such and such, dated such and such, for submitting necessary papers in connection with the area claim in favor of Pranab Kumar Roy for the period such and such, I do hereby inform you that Pranab Kumar Roy was absent from his duty to such and such date as per staff attendance register. Before it his last attendance as per staff was 5/7/24. Therefore, it is difficult to decide if any area claim should be admissible to him during the above mentioned period. Kindly provide us proper guidance in this matter. So do whatever needed in this regard. Milord,
Next letter, my lord, of the day.
Then District Inspector of Schools, whether the petitioner made any application before the school authority for sanction and leave for the period he remained absent from such and such. Whether the said leave was sanctioned by the competent authority, if not applied for leave, what kind of action was taken by the school authorities?
Now, what is the reply of the school authority? Next page.
In response to your first query, I do hereby inform that no application was made by the as per available office file. These are very Milord safe side. This is Milord.
This is the reply of the school
Yes.
authority.
Subsequently, Milord, if it is found, ultimately, Milord, they will say that as per available records at that point of time.
Oh, 1 minute. Same 6th of January, the very last page,
My lord,
the last few lines.
my lord.
The school authority requested the petitioner to resume his duties, but he did not.
Hmm.
Where are the documents to show that you directed the petitioner to resume duties?
The school authority directed. It is the reply of the school authority. They are telling us that they requested the
Did you
petitioner to
verify?
resume. Yes.
Did you verify?
Malad, this
whether-
kindly direct the school to produce those documents.
Did you verify? You are the DI.
Malad, it's a letter of 2015, my lord. After 10 years, my lord,
Report, page 73.
Milord,
if your lord say,
After 10 years, what?
my lord, these letters, my lord, how we can verify? Say, school authority can say, but they have mentioned the letters.
If
Date.
the school can verify, you can verify it from the school.
Very well, we shall collect those letters from the school authority. my lord.
shall, Milord.
We shall
What
collect
is
those
this
letters.
mechanical exercise?
No, but it is on record the reply of the school authority in the specific date that on such and such date they asked the
Why
petitioner
don't
to
you
join.
seek for the documents that yes, all right, you have issued letters. Let us see.
Well, we
Is
shall
it
collect
the
it.
court to do all these
Not kindly,
things?
2 days, can you take it on Friday? We shall
Milord, possibly your lordship is not required to do so. With deepest respect to my,
Are those letters on record?
Milord, kindly see DI's report, his client's report, 73.
73.
Yes,
Read petition.
read petition of your lordship's brief.
Yes.
We, the undersigned, as directed by the DIAC Purva Medinipur, made an inquiry to such and such regarding the complaint made by Pranab Kumar Rai, that is the petitioner at the time of inquiry at the said school. TIC, HM, Secretary, MC, and all teaching and non-teaching staff of the school were present in the spot. After detailed and thorough inquiry, we came to the following observation. At the time of inquiry, as per teacher sergeant register available in the school, it is found that Mr. Roy joined his service on 21st December 87 and continued his service till 2nd June 2012. He is suspended from 3rd June 2012 to 4/7/2014. Following the court order, he joined the school on 5/7/2014, but no class was allotted in favor of him on that day. Even his name was not included in class routine. With an alternative casual staff, the classes of Mr. Roy were being held. But at the time of his leaving the school, after the end of the school hour on the day, he had to take police escort to protect him against the fierce agitation. The complainant, Pranab Kumar Rai, 80, assistant teacher, school was absent, though he was informed of the DI schools such and such to be present on that day at the time of inquiry. At the time of discussion with the staff, some staff said that more than 500 persons, including men and women
Gathered
Gath-
in front
gathered,
of the
it should
school
be.
gate.
in front of the school gate on that day before our going to school. These persons were gathering in all protested with slogans in loudspeakers against Pranab Kumar Roy, so that Mr. Roy cannot enter the school and join his service. They also threatened Mr. Roy of dire consequences. At the time of inquiry, the TIC and the HM Secretary MC told that they have no objection against Mr. Roy to join, but the local situation, there is retaliated against him and his life may be in danger. The Secretary, MC, TIC, HM also expressed their views, what they would help in all possible ways if Mr. Roy is possible to take transfer to any school and continue his service and drawing salary. All the staff informed that as teacher, Mr. Roy is well enough. It is noted that HM of the school is also under suspension. As per letter of Mr. A.K. Roy Chaudhary, the Secretary of the West Bengal Board of Secondary Education, V-Day memo dated 27/11/24, the DI Purva Mednipur was directed to take necessary steps so that Sri Roy would be able to get his due salary and perform his duty in the school. After being physically assaulted in this way to school, in front of the school gate, Mr. Roy lost a diary in Tamluk PS. We, after inquiry on the view, Pranab Kumar should be allowed to join school and his salary along with all arrears should be released in favor of as early as possible, as he with his family members are in a very financial crisis due to being deprived of a salary long time. To solve his aforesaid problem, his service should be regularized and his security should be ascertained. Dated, Millard, 17th March 2015. So today all the reports filed before your Lordship's court is absolutely contrary, Millard, to the tenor of this report. So, Millard, this is a futile and perfunctory exercise of power, non-application of mine. He is wasting your Lordship's time.
Yes. This is the report.
Why the present DI is so against Millard, an employee? His
This
family is
is- one minute,
Why?
one minute.
Yes,
Page
why submission,
73.
Malata? How?
Page 73 is by whom?
Yes.
Is it by the,
at the instance DI office. We the undersigned as directed by DI.
as directed by DI?
Mednipur made an inquiry.
We, the undersigned, who are the undersigned?
Undersigned, Millard, Millard, it was 72. Millard, this is Millard, page is not
Legible.
yes. 5 is a countersigned by 5 District Inspector of Schools.
Hmm.
My lord got it.
Yes.
Yes. So
It's countersigned, prepared by whom?
prepared by these persons. The seal, Millard, is also kindly ask them to produce the original record. If he has doubt in his mind, Millard, at the late hours, Millard.
Who is doubting?
The board also, Millard, 71. Today, Millard, I put this question to myself. My lord directed the DI to take an effective steps. Whether these reports are in line with, Millard, the direction as well as the record. Otherwise, Millard, the entire exercise, Millard, this exchange of letters between the school and the DI is absolutely
The
meaningless.
admitted fact is that he worked till 2014. For that period, he got already the salary. Pursuant to your Lordship's intervention, we have released the salary. Thereafter, he did not join.
He was not in a position to join and
Yes.
he did not join are two different things.
He was
And his
very well. I am accepting that he was not in a position to join. 2018, he was convicted. But he till date, from 2018, he is behind the bar. Now, perhaps when he was superannuated, 2023. 23 was superannuated. Now, during this period, he was absent. He will be treated as unauthorized absent or whatever. Maybe he was absent as per our record. But unless that absence is regularized, can we release this salary or area salary? Anything else? Who is
Superannuation,
who is responsible for the same? The school is
suspension allowance. That is the reason the
Suspense,
court
yes.
restricted only till the subsistence allowance.
no. He has area salary was released till 2014.
All right. What about the
Admissible
subsistence allowance? He is in under
But instead of
suspension.
subsistence, entire salary was released. Entire salary for that period up to 2014 was released.
Entire salary?
Yes, my lord.
How could you?
Till conviction, what about this? Millard? He is again, Millard. He will be in a fix, Millard. Kindly seize, Millard. Kindly seize, Millard, page 84. He is again submitting contrary to his record. I am not saying that he is innocent of fact. I am saying, Millard, his unintentional omission, Millard,
Let
that is
me
Millard
file an
problematic.
affidavit in opposition to that.
Kindly please.
I have explained everything, my lord. Whatever we have done and what we take steps we have taken. my lord.
What is the explanation? What will you,
My lord, what
specific
explanation regarding what? My lord, now
opposition?
he is claiming area salary for that period. But unless his
Government is not in a position to tell
unauthorized
your
leave-
lordship what the admissible
unless
due
his
is.
unauthorized leave is regularized and sanctioned by the competent authority, can that DI release salary, my lord?
How can
I
you
am
put
asking
this
my
question to
question.
court, Millard? It is the highest court of the state, Millard. Kindly seize what the
73.
84, Millard, kindly comes. That is also, my lord, there is no discordant note between the two highest authority of the state. Kindly cease. I am reading for my lord the last paragraphs. 2 paragraphs. The school authority submitted that they had no objection in resuming duty by Pranab Kumar Rai. They also submitted they had no objection in case of transfer of the writ petitioner to any nearby school. Mrs. Shumita Mukherjee submitted a copy of the inquiry report prepared by 2 assistant inspector of the school of the office of the DI, Purva Mednipur. Then Millard kindly comes. Hearing the persons present and perusing the available records, including the inquiry report submitted by the representative of the District Inspector of Schools, Purva Mednipur, the Government of West Bengal in School Education Department published the West Bengal School Service Commission Mutual Transfer Rule 2012, such and such, wherein the West Bengal Central School Service Commission was authorized to recommend for mutual transfer of 2 incumbents to their reciprocal places of posting on receiving the report of the hearing committee. The Government of West Bengal in School Education Department also published the West Bengal School Service Commission General Transfer on Special Grounds and Reallocation Rules 2015 with a notification such and such, wherein either the Regional Commission to the Central Commission was authorized to recommend the transfer allocation of any teaching or non-teaching staff. In terms of the said rules, the School Education Department may be recommended prayer for general transfer on special grounds after proper examination.
Tell me one thing. When was he convicted?
2018, my lord.
2018.
And
18th April 2018.
he was in service till 2014.
No,
Yes, my lord.
it should be treated as, my lord,
Performed
2018 because, my lord, he was not allowed to join. And, my lord, the Commissioner of Schools said, considering the above, I am the opinion the school authority should cooperate and show utmost sincerity so the petitioner can resume his duty as assistant teacher in the such and such. It is also made clear that the school authority must not engage any unapproved casual person for taking classes of the biological sciences.
Yes, so from 14 to 18.
Then
he
sentence,
could
my
not-
lord, kindly allow me, my lord, for a minute, my lord. It is also made clear, regarding the area subsistence allowance salary in favor of the writ petitioner, the school authority and the DI of schools, AC Purva Mednipur must act in accordance with law. I am also of the opinion the commission such and such under the West Bengal such and such, transfer on special grounds such and such in accordance with law. Thus the representation of the writ petitioner. So the DI had taken, the DSC also has taken note. I should be, my lord, given the entire salary for the period till I was convicted. So the question, my lord, my journey, my lord, did not stop at, my lord, 2017.
But then since you
My provident
were absent, till your absence is regularized, possibly the DI will not be in a position to take steps. Right?
I bow down.
So is the board a party?
Board.
This absence is required to be regularized.
No, board is not the
not
party.
party, my lord.
I can, my lord, add board, my lord, and if your lordship feels, your
Because
lord,
regularization has to be done by the board only. Otherwise,
Committee will sanction the leave and thereafter approve. the leave.
forwarded to the board for
your
approval.
lordship has found that the school, DI, DSC, everyone, my lord, there was made this statement in unison that, my lord, this was not done, and, my lord, the fault cannot be attributable to me. When this is the admitted position today, my lord,
Now things have to be regularized.
yes, my lord, I am making, I am implementing, my lord, the West Bengal Board of Secondary Education, permit me to
Is the
serve.
school a party?
Yes, school is a party.
Is the school represented?
No,
No.
but serve.
Never, my lord.
And
Never appear, my lord.
is the school recommending your leave for regularization?
Today, this question possibly, my lord, after, my lord, this order, which I have shown, page 73 and 84, my lord, the school is bound by this record.
Then the school has to act.
My lord, the school has to act. I seek your lordship's kind indulgence, give a direction upon the school, my lord, to act in terms of this, the direction, page 73 and 84. I am making a prayer. I am confining myself within the records. I am not traveling beyond the records. The other parts, my lord, the admissible dues, my provident fund, my right, my lord.
What about the other dues of the petitioner?
They have not calculated.
will
They are
not
not in a
get
position to tell your lordship.
Seven except the provident fund, my lord, I have the instruction from the DI, my lord, they have received the provident fund amount.
Provident fund amount
Yes, madam.
received.
So 7 provident
No.
fund, nothing.
Kindly, my lord, ask his client, my lord, to file, my lord, to make this statement on affidavit.
Are you sure you're not?
My client, my lord, my client's wife came, my lord,
Yes.
and said, my lord, the portion, a certain portion was released, but the area, which also includes, my lord, the provident fund calculation also.
That means the portion that has been received does not contain the PF component.
Post, no.
Matlab, PF
Post
component
conviction,
up to 2014. Matlab, he is
But he
claiming
is
if he,
confining
if,
himself
if
to
he gets the salary
2014.
up to
I am saying 2018,
then matlab,
2014 to 18.
matlab, there will be some area.
2014, 2015, 2016, the all others, my lord, they have given go by. School said, my lord, there was an agitation, commotion. The reason behind this skirmish, my lord, is absolutely clear to them.
Please show me what will be your entitlement upon your conviction.
My lord, that is the subject matter of challenge in the constitutionality. That so far as the family pension is concerned, my lord, I have made one submission. If your lordship kindly, my lord, have the charity to consider, my lord, I have said, my lord, that the pension is a property according to me, my lord, subject to what my lord says. Family pension, my lord, includes pension. If the pension is a property, and if it is heritable, my lord, then the question of heritance, this concept comes from, my lord, the Hindu Succession Act. The Succession Act, my lord, says.
Then it will be hard.
No, my lord, in the meantime, this admissible dues, my lord.
After your
His salary.
conviction,
No, after conviction, my lord, kindly do not go there. After conviction, do not. Before conviction, I am confining myself for the present moment. So your lordship's order may kindly be complied with.
till 14 you've received everything.
So till 14 to 2018, my lord, till to conviction. Provident fund
Conviction is in 2018.
to April 2018. Before that,
Right. Before that,
the managing committee will be directed when to regularize in terms of 7384.
you serve this school. Please,
I have served.
none appears on behalf of the school authority.
And the board also, my lord, board, my lord, kindly permit me to implement the board as a party respondent.
Let
And
this
if it so
school,
commences to your lordship, my lord, I can serve a copy to.
let this school come
really what-
first. School ke bola to? Na, ki bola? None appears on behalf of the school. Stop. Let notice be served upon this school, intimating that the matter will appear in the list on 28th January, 28 तारीख. Stop. The school shall forward a report disclosing the dues of the petitioner, comma, if any. Stop. Let a further notice from the end of the DI be served upon the school authority, communicating the order of this court. Stop. In the event the school is not represented, comma, the necessary order will be passed. Report by the DI. Secondary Education, Purva Mendipur. Signed on 9th January 2026, filed in court today, be written with the records. Next.
29th January, my lord.
My lord, I apologize for intervening, my lord, in like this, my lord. Item 23 was dismissed for default, my lord.
Nobody was there.
I was right at the doorstep, my lord, when it was dismissed. And my lord, senior friend for the state is also here, my lord, in court.
Who's for the state?
He's just here, my lord, right at the door.
ये 23 নম্বরের ফাইলটা দেখি এটা কি এটা এক্ষুনি হলো না
Hello.
23টা আছে 23টা ফাইল আছে টুডে
I'm grateful, my lord.
My lord, I have,
ওটাকে ইয়ে করে অর্ডারটা রিকল করে নেবেন
I'm grateful, my lord.
my lord, I have hand over the report also.
Hi, Baba. Well, we appear for the state respondents.
yes
The petitioner's only grievance, my lord, is to refund the amount, my lord, recovered from page 2020. 1 lakh.
20 to nahi. Oh, 22.
That yes, from the the treasury challan due to non-settlement to fix up the date of approval of higher scale of pay. See the wrong fixations due to my lord the business.
State your submission.
My lord, kindly takes page 19 once. Now, this is the order passed by the DI of schools dated 26th April 2013. Lordship sees at the bottom, 26th April 2013. Now, my lord, he says in his averments, then beyond this, I'll not make submission. He says in the averment that I have made the payment in 2014. Now, my lord, he files this writ in 2025. My lord, limitations your lordship will have held will not apply in writ proceedings. But my lord, there has to be subject to correction some paragraphs wherein, my lord, at least the delay has to be not explained but stated why. There is no subject to correction, nothing. 13 order pass, 14 order pass, I submitted in 2015, I come in 2025 saying give it back to me.
So 2013,
Lordship.
the refund order was passed.
That's right.
30th April 2013,
Yes.
only 4 days before.
All right, but then you approached the court in 24
24, my lord,
after
the-
10 years.
No,
My
after
lord,
the
kindly,
judgment,
and kindly sees paragraphs, there is no
after
paragraph.
the Abhijit Boy's judgment, he refund the amount, 7 lakh something, PPO was issued.
No, it was Swapna Das, Abhijit Boyte.
My lord,
What
PPO
has
was
Obijit Boito got to do with this?
June 20, because my lord, at that time, he did not, my lord, the challenge because he was not
Obijit
eligible.
Boito
I tell you, he was not eligible for pension. That is why he did not challenge. Subject to after the Abhijit Boydo, he refund the amount and pension payment order has been issued.
That is different. But
Pension,
then this has got nothing to do.
no,
This is
when,
regarding your
when the pension payment order was issued, officer, my lord, the authority, my lord, detected that you drawn, my lord, excess amount. That is why, my lord, but the delay, admittedly, my lord, the 2014, he refund the amount.
Listen, Obijit Boito and your case, wrong fixation are completely two different issues.
Abhijit Boydo's case is not the related to,
Then
but the in view of the Abhijit Boydo judgment, he refund the amount and pension has been
this
sanctioned.
amount which was found to be drawn in excess does not have any relation with
Not
Obijit
relation,
Boito.
but I
Then-
tell you, Lordship, so that the Abhijit Boydo, after the Abhijit Boydo judgment, I tell you, Lordship, he refund the certain amount of government share within
that is different.
pension payment order. When the pension file was processed, the wrong fixation was detected after the conversion from CPF to GPF.
No, I do not take it because here it is absolutely with regard to your postgraduate scale of pay. No, sorry, sir.
I just mailed there. Page 18, just here also, see, page 18, this amount was refund on the on the head of the government share. Page 18, you also can see page 18.
Page 18 is Obijit Boito.
Abhijit Boydo.
Right.
After
And page
that,
19 is different.
This is 19. This is the order was passed in 2013, just 4 days before my retirement.
Yes.
4 days my retirement. Now the page 20 and 21, I have to refund the excess amount drawn in view of the wrong fixation of higher scale of pay.
Yes.
Higher scale of pay was granted.
Ah.
Only date was different, my lord, for drawing salary.
But since you have approached after such a long
This
period,
is,
I'm
my
not
lord,
going to.
this honorable court, my lord.
No,
there is
sorry,
a
I'm not.
judgment. My lord, I produced the judgment of this honorable court. You will also kindly see, my lord, considering the 79 years delay, my lord, the honorable division bench held that. You will also kindly see the second page. Denying, my lord, the division bench judgment as well as, my lord, second page, you will also kindly see.
Hmm. Yes.
Paragraph second page, well, 15 of that judgment has been quoted.
Hmm.
Well, 299979 also, my lord, I have a copy. Delay, my lord, my money, my lord, that enjoyed by the state, my lord, delay cannot be counted. Because my money, my lord, they have deducted due to wrong fixation. They paid, my lord, on the basis of their fixation. It is not a case that I am a headmaster, I have fixed the amount. My lord, that judgment, and also, my lord, the honorable division bench, my lord,
তো কাউন্ট হবে না।
This is the division bench judgment, my lord, the সব রিপোর্টেড হয়েছে। কোনটা দিল?
Yes.
Page 3, the bottom portion.
Hmm.
This one delay has been considered by the honorable division bench. Now this is also a division bench judgment, my lord. Now the issue has been settled, my lord. My money has been utilized by the state. আশিস দাস উত্তরে দিলাম পরেরটা ওষুধই পড়ছে ছোট পড়ছে এটা ডক্টরকে দিয়েছি পড়তে নামটা দিয়েছি টিচার ছিল এটা দিয়েছি
টাকা পাওয়া উচিত। এখানে দিয়েছি টাকা পাওয়া উচিত। Hardly.
Produce Tarsem Singh.
and sensing Joydeep Singh.
Hey, Kailash. 2008 3 SCC 648.
Well, may I hand over the
No, my officer is here. 83 SCC 648. Union of India versus Tarsem Singh.
আমার তো এখানে নেট ধরতে না। পার্সেন্ট পাঠিয়ে দিই কেন পাঠিয়ে দিই
Tarsem Singh, TARSEM.
জানি না কিছু সেটা পার্সেন্ট না পড়ে বের করো আজকের দিনে হবে নাকি তো
Last paragraph 8.
কি আছে প্যারাগ্রাফ আরে ওটা রিনিউ করতে গেলে যদি খুলছে না দাঁড়া না কি পাঠিয়েছে উজ্জ্বল
Please come. The petitioner is a retired school teacher. Stop.
নাকি ওটা দিই
He retired from service on attaining his normal age of superannuation on 30th April 2013. Stop. Prior to his retirement,
রিপোর্ট ফাইল করতে বলবে না কি করতে বলছে
Prior to his retirement, the respondent authority found discrepancy in the payment made to him and directed the petitioner to refund certain amount which was received by him in excess to his entitlement. Stop. Challenging the same, the petitioner filed writ petition before this court, being WP number 2524 within bracket W of 2013. Stop. In compliance of the order passed by the court on 17th April 2013 in the aforesaid matter, a hearing was conducted by the District Inspector of Schools, Secondary Education, Nodia, in the presence of the headmaster and the petitioner. Stop. After hearing all the parties, the DI observed that the prayer of the petitioner for grant of postgraduate scale of pay on and from a particular date cannot be allowed. Stop. The authority directed the school authority, now the DI. The DI directed the school authority to review the pay fixation of the petitioner, and the petitioner was directed to refund the overdrawn amount in the treasury. Stop. The petitioner accordingly refunded the excess payment of rupees 1,07,832.
Twice, my lord. Second page also. Total
25
2,25,453.
আচ্ছা, টাকার অ্যামাউন্টটা লিখুন 2,25,453 by way of 2 treasury challans. Dated 27th January 2015 and 25th February 2015. The petitioner in the instant writ petition prays for refund of the aforesaid amount. Stop. It has been submitted that the petitioner was no way responsible in the wrong fixation of pay, and the respondent authority could not have directed the petitioner to refund the excess amount immediately prior to his retirement. Paragraph. It has been submitted that the petitioner has also refunded certain amount in the treasury in terms of the judgment passed. No, treasury on account of the government share of provident fund to receive the contributory provident fund benefit in terms of the
In the paragraph 8.
notification issued by the state government. Stop paragraph. Learned advocate representing the state respondents raises an issue of delay in maintaining the writ petition. Stop. It has been submitted that the petitioner retired from service in August 23rd, 2014. When did he retire? No, retired from
April 2013.
ঠিক 30 April 13. And
30th April 2013.
right, and the instant writ petition has been filed in May 2024. Stop. There is no mention with regard to the delay in approaching the court. Stop. In reply to the issue of delay that has been raised by the respondents, learned advocate for the petitioner relies on the order passed by this court on 27th February 2019 in WP 7691 within bracket W of 2018. Bina Ghosh Sarkar. Order dated 9th January 2014, passed by the Honorable Division Bench of this court in MAT 1829 of 2013. Can 12040 of 2013, Joya Ghosh versus State of West Bengal and others. Yes, sir. In the WPST matter, was delay considered?
The PST melody, Ashutosh Bhattacharya.
Ashutosh
Yes,
Bhattacharya.
delay has been considered.
Where is it?
That is page 5. This is
Delay has not been considered. There was no delay. This is on merits. আচ্ছা ওটা বাদ দিন কি বললাম এইটা হবে না WPST টা হচ্ছে না ম্যাটটা হয়েছে তারপর হচ্ছে কমা দিয়ে and the judgment passed by the honorable passed by the court on 18th January 2017
ওইটা দিয়েছে
in this case also whether delay was considered
highly consider melody
where is the delay portion
with judgment melody division bench judgment.
in the matter of Shivarani Maiti
Yes, yes.
where is the delay
The that Sivarani Maiti melody that paragraph has been set out melody in the judgment of the Honorable Justice Mushi Bhattacharya. First judgment it was really light. That-
show me
that
from
paragraph-
no show me from Shivarani where is the delay considered
কত নম্বর প্যারাগ্রাফটা দিয়েছে
this is on merits
melody page 11 paragraph 15.
all right the only is whether the writ petition should be ended in spite of delay of 17 is approaching the court
That the relying a division bench judgment we should take it up to 2010. সত্যি
আচ্ছা January 2017 in WP 29979 W of 2016 এটাকে কপি করে নেবেন উইথটাও কপি করে নেবেন
and melody that division bench judgment melody relied paragraph 15 this is the judgment. Paragraph 15 which has been cited by this judgment. 933.
cited where
The Sivarani Maiti.
Shivarani Maiti
Paragraph 15 melody.
yes paragraph 15 19
That is the wrong melody. This is the 933 not 1933. Paragraph 15 melody citation
yes
MAT 1933. This is 933 not
all
19.
right
Date is same.
বললাম
সেপ্টেম্বর 1010
ওটাই
such and such wherein the court was pleased to allow the writ petition despite there being delay ঠিক আছে I have considered the submissions made on behalf of both the parties. Stuff. The in Shivarani Maiti within brackets Supra and Bina Ghosh Sarkar within brackets Supra, the court took note of the judgment passed by the Honorable Supreme Court in the matter of Union of India versus Tarsem Singh, reported in 2008, 3 SCC 648. Stop. The court also took note of the fact of the judgment passed by the Honorable Supreme Court in the matter of State of Punjab versus Rafiq Masi within state of Punjab and others versus Rafiq Masi within bracket whitewasher and others reported in 2015 4 SCC 334. Stop. In Rafiq Masi within bracket Supra, the Honorable Supreme Court laid down the situations where recovery is impermissible. Stop paragraph. In Tarsim Singh within bracket Supra, the court took note of the delay on the part of a litigant in approaching court. Stop. In Rafiq Masi, the court clearly laid down that recovery from the employees due to retire within 1 year from the order of recovery is impermissible. Stop. In the instant case, the petitioner retired from service on 30th April 2013 and the recovery was made and the prayer for refixation of the scale of pay of the petitioner was made prior thereto. Stop. The petitioner approached the court in the year 2013. When order was passed, directing the authority to consider the grievance of the petitioner. Stop. Prior to his retirement, a decision was taken by the authority regretting the petitioner's prayer for higher scale of pay. Stop. The said decision was taken in compliance of the direction passed by the court.
No, my lord, the
Stop.
higher scale of pay was not rejected. Only, my lord, the date of the effect of higher scale of pay that has been rejected.
That is exactly the issue.
Yes. And DI approved the higher scale of pay.
From a particular date.
Yes.
And it is because of this date discrepancy, the overdrawn amount has been deducted.
And
Isn't it?
possibly this remains unchallenged.
আচ্ছা কি বললাম ঠিক তার আগের লাইনটা pay on and from 8th October 1982. ঠিক আছে ঠিক আছে The petitioner accepted the said position
Yes.
and refunded the amount which was found to be drawn by him in excess of his entitlement. Stop. The instant writ petition has been filed on 15th of May 2024 with a prayer to direct the authority to refund the said amount. Stop. In the meantime, the issue of the issue as to whether the teachers would be entitled to receive contributory provident receive the pension amount upon refund of the employer's share of contribution from the GPF to the CPF scheme was pending consideration before the court. Stop.
That is the reverse one, CPF to GPF.
CPF to GPF. ঠিক আছে? The petitioner, in terms of the direction passed by the court and in line with the state government notification, refunded the employer's share of contribution along with interest, and thereafter pension was paid to the petitioner. Stop. The petitioner in the instant case has tried to portray that as the employer's share has been refunded along with interest. That's the employer's share of contribution of provident fund along with interest. Accordingly, the authority ought to refund the amount which was found to be paid to the petitioner in excess. Stop. Fact remains that had the petitioner not refunded the employer's share, he would not have been eligible for receiving his pension because the petitioner initially did not belong to the pension scheme. Stop. Next. The issue of fixation of the scale of pay and the issue of refund of the employer's share of contribution are completely two different issues. Stop. The refund may not stop. Issues and the refund was made by the petitioner on two different heads and accounts. Stop. One was, put a semicolon deben. One was for refunding the excess amount drawn, and the other was refunding the employer's share of provident fund. Stop. the entitlement of the petitioner to receive his pension arose after he refunded the contributor's share in September 2014. Stop. The petitioner, no, the order of the District Inspector of Schools dated 26th April 2013 was never challenged by the petitioner before any forum. It is for the first time by filing the instant writ petition in May 2024 that the prayer for a refund of the overdrawn amount has been made. Stop. In support of the submission that as the money of the petitioner was wrongly enjoyed by the authority, accordingly, delay in approaching the court ought not to be a deciding factor in the instant writ petition. Stop. Now at this stage, the judgment passed by the Honorable Supreme Court in the matter of Tarsem Singh within brackets Supra comes to play. Last paragraph, Jan. Stop. The Honorable Supreme Court Supreme Court held that there has been delay of 16 years. Held that the delay of 16 years would affect the consequential claim for arrears, and the High Court was not justified in directing payment of arrears for the said period, and that too with interest. Stop. The Supreme Court held that the High Court ought to have restricted the relief relating to arrears to only 3 years before the date of the writ petition or from the date of demand to the date of writ petition, whichever is earlier. It ought not to have granted interest on arrears in such circumstances. Stop. The court was pleased to set aside the direction passed by the division bench of the High Court. Stop. In the instant case, the petitioner has delayed in approaching the court for more than 10 years after his prayer for refunding the overdrawn amount was passed. Stop. There is not a word mentioned in the entire writ petition mentioning far less explaining, the delay in approaching the court after so many years. Stop. On the contrary, a picture has been tried to be portrayed that as the petitioner refunded the amount in line with the government order passed in the year 2014, it was improper for the authority to direct further refund of the overdrawn amount. Stop paragraph. The court is not accepting the submission of the petitioner. Stop. The court is of the opinion that as the petitioner was directed to refund the overdrawn amount way back in April 2013, which the petitioner admitted without raising any grievance, accordingly approaching the court after 10 years of the said order seeking refund of the amount deposited by him cannot be accepted. Stop. The writ petition fails and is hereby dismissed. আর একটা ডাকুন দেখি।
দিদি বাবু
Position. You kindly see my lord's last order.
For the state. I'm late by Mr. Roy, acting for SS.
There has been a direction from
Is
Istanbul court.
there a report from the state?
Yes, sir.
Please. What is your prayer?
My prayer is for my lord transfer. My lord, if I just could take your lordship, my lord, that I just made this application for transfer, my lord, on the medical ground, and that the lordship will see at page number 23. I'm sorry.
Are you aware of this copy?
Lordship, there is 2 copy only.
Give a copy.
May I just see and come back to you? Very well.
So it doesn't serve any purpose.
So, my lord, so in that event, my lord, let the order your lordship is we are getting, my lord, for the single teacher, my lord, let it be also passed here.
This is not a single teacher, but then it is beyond the 10% of the teaching staff.
That was
Please come.
seriously, and thereafter, my lord, lordship kindly sees the last one. That my, I'm sorry.
The petitioner's prayer for
Number
transfer.
23, last application was rejected as single teacher.
The petitioner's 23.
Page number 22 and 23.
Page
22,
number 22.
yes. My lord, 23, my lord, lordship was seen, I was a single teacher, but lastly, at page number 22, serial number 2 and 1.
Achha, the petitioner's prayer seeking transfer stood rejected. By the District Inspector of Schools on 28th October 2021 with the observation that the petitioner was a single teacher in the concerned subject. So, the petitioner reapplied for transfer, which stood rejected by the head of the institution on 27th January 2022
My lord.
with the observation that the application exceeded the 10% permissible limit of the teachers eligible for transfer. Stop. The petitioner is aggrieved by the same. Stop. The court directed the state respondents to revert with instruction from the District Inspector of Schools, Secondary Education, Paschim Mednipur, with regard to the staff strength of the school. Stop. The District Inspector of Schools has forwarded a report signed on 7th January 26. Stop. The staff strength of the school has not been disclosed in the said instruction forwarded. Stop. Paragraph. It appears that more than 4 years have elapsed after the petitioner's application for transfer stood rejected. Stop. There may have been a change in the staff strength of the school in the meantime. Stop. Next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to file fresh application offline to the school authority. Stop. On receipt of this application from the petitioner, comma, if any, comma, the same shall be considered by the school in accordance with law at the earliest, but positively within a period of 8 weeks from the date of filing the application. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the school authority. Writ petition stands disposed of.
Grateful.
Didn't your DI understand what he was supposed to do? The DI has simply reiterated the facts of the case.
Yes, Lordship.
What was the requirement? The court could have disposed of the writ petition on that day itself, unnecessarily keeping it pending for so many days.
But the suspension of portal should not stand in the way, Lordship.
Suspension of the Uchosri portal will not stand in the way of the respondents in considering the application of the petitioner seeking transfer. I have mentioned offline also. That is permissible. Call the next one, please.
Grateful.
Earlier occasion, your lordship.
And for the petitioner, my lord.
Earlier occasion, your lordship asked for the medical reports, my lord. That DI actually searched for the medical report and the CMH actually
Lost it.
not lost it, my lord. It is not
it.
not, my lord. It is not found because that application is filing online. On the portal is suspended till today, and that application should be submitted offline. And as per the
That resulted in
and-
fresh medical examination. Let us come to the
Yes,
point. That resulted.
that
Where is it?
Yes, it is recorded. Yes,
it
yes.
is
That
recorded.
resulted into the
It is
fresh
recorded.
medical
Page,
examination. My
Page.
it is in the report. It is in the report, your lordship.
Report.
Yes,
That has been
that
filed.
Yes, yes, yes.
page number
Page number last annexure. On 7th of January 2026, she has been made to undergo a medical test. The report is
phrase
yet to be placed before your lordship.
happen
Where is it?
No, the
that it is
report has not come.
Not come,
Only
my lord.
medical examination.
Just
When will the
arrangement.
report be available? 7th, the examination took
Yes,
place.
7 is medical examination is
When
took
will the
place.
report? Acha,
and
এখন তো দেখছি
But
not
my lord,
come.
only one thing, my lord, my case was otherwise. When I made the application, it was rejected on the ground that previously my medical certificate was not accepted. That is why my next application was also rejected. Now they have lost the document. Your lordship wanted to see the actual report. Now that has been lost. Based on that, my candidature would have been decided. Now fresh medical report has been done. My lord, it is getting deviated.
Let us see.
Very well. There may be a deviation, my lord. There
That
may be a deviation.
Never submitted that application for
Wait.
the
Wait.
I could not because online it was.
From the report forwarded by the District Inspector of Schools, Secondary Education, Malda, signed on 9th January 26, it appears that medical examination of the petitioner was conducted by the CMOH, Malda, on 7th January 2026. Stop. Let the report of the CMOH be placed before this court on the adjourned date, released 27th of January.
There was no direction of your lordship to conduct a fresh test, only the previous record.
Well, if it is not available now, you have to rely on it. What can be done? Call the next one, please.
Grateful. 27 January. ঠিক আছে? যদি 27 তারিখে
Lordship, item number 28, I have instructions to appear on behalf of the added respondent, the wife. I have received the wakalatnama today itself. Lordship, I need some time to obtain instructions.
Lord, I
Did you
appear on,
file the wakalatnama?
Yes, Lordship, I have filed the wakalatnama in the department.
Acha, ঠিক আছে.
my lord, I appear on behalf of the petitioner.
Yeah,
My
yes.
lord, kindly, my lord, seize, my lord, the supplementary affidavit for a moment.
Let him come prepared at least. He is appearing for the first day, doesn't
DI
have any instruction.
My lord, the DI, my lord, has already inquired in the meantime.
All right.
And my lord, the DI, my lord, has passed, my lord,
It's a supplementary.
the supplementary is with my lord.
Yes.
My lord, kindly, my lord, sees, my lord, the supplementary affidavit.
Yes.
Page 16. My lord, kindly sees page 16, 16.
Hmm.
Lord, for solution of the matter of nomination and correction of IOSMS portal regarding so and so, the office arranged hearing with the school
The last
authority.
4 lines.
My
The
lord,
instant
yes.
case is disposed of.
My lord. My lord.
Uttam Das is requested to submit copy of the affirmation regarding marital status.
My lord.
Did you submit?
Yes, my lord, I have. Page 17 is the affidavit.
All right. School authority will confirm. Did the school confirm?
I am for the
Did you
state file.
confirm?
My lord, no, my lord, still, my lord, the record is lying with ADI.
After
why-
copy of info affirmation, necessary action will be taken by the to correct the iOS portal.
My lord, the IOMS portal, my lord, that should be record is lying in the additional district inspector.
Did you confirm what document the petitioner has submitted before you?
Lord, my lord, on the last occasion
I
directed
have
them to
confirmed.
produce
My lord,
my lord,
yes.
the original records.
Yes, we have confirmed, but problem is that yes, that there is a mistake. We have, my lord, record is lying with the additional district.
How
No,
do you
no, my
identify
lord.
the mistake if the record is there with somebody else?
Because, my lord, they have to send back the record to the us.
How do you know that there has been a mistake?
Because, my lord, at the time of IMS portal, my lord, incorporation of the name, there is a mistake. We have, my lord,
So you have identified the mistake.
yes, my lord.
The name of the petitioner's wife was wrongly
Yes.
written. Correct it.
My lord, kindly see the
My lord, kindly pass a direction, we shall correct it.
Why? You for correction of a mistake, you need a direction of the court.
Because, my lord,
At the time of making the mistake, there was no direction.
my
For
lord,
correction,
because
you need a
IMS
direction.
portal, they have incorporated, there is some mistake, my lord. But if, my lord, record is lying with the ADI, my lord. That's why, my lord,
Did
IMS
you
portal.
intimate the ADI that there
my
is a
lord, it
mistake?
is not right, my lord.
Yeah.
It is not correct.
It is not.
Please stop.
No,
My lord, can you
It-
see the page 16, my lord, inquiry report, which
Ah.
have been filed
What
by
does
the,
it say?
my lord, can you see the matter is as follows? The headmaster of the above mentioned school told in the hearing that Sri Uttam Kumar Das, ex-assistant teacher of the school, is a married person having been solemnized sometime in the year of 2012. But incumbent Uttam Kumar Das, ex-assistant
Listen,
teacher,
after all this,
Yes,
after all the school,
has directed the petitioner
yes.
Yes.
of the school to submit
Yes.
copy of the affirmation regarding the marital
Yes,
status.
madam.
Has that been done?
absolutely.
Lordship,
Not done. Lord, kindly see now page 19, Lord, for a moment. Lord, the DI, my lord, again asked the institution, my lord, the head of the institution. He's
What is the school doing?
But school is total responsible for
Show
that.
me the documents. There is a direction upon you to show the documents relying on which you inserted the name of the wife of the petitioner. Where are the documents?
My lord, there is a
Not ready.
Even, my lord, the ADI, my lord, has asked, my lord.
My lord, there is a IMS portal. I have taken my lord IMS portal.
I will not look at it.
My lord, kindly give a direction to file an
Why?
affidavit. My lord, I shall incorporate it by filing an affidavit.
I'll direct the head of the institution to appear in court personally.
Yes.
If this is your conduct.
My lord, kindly my lord, fix a date. I shall, my lord, direct come with it along with.
There is already a direction. Why are you not ready?
What my learned friend is showing is at page 20 already.
Lordship,
My lord,
Page 20 of the petition. That is IOSM portal. That is the
Please
incorrect
come.
posting.
Despite direction passed by the court on 2nd January 2026, directing the learned advocate representing the school to produce the documents relying on which details of the lady got incorporated in the service records of the petitioner, the same has not been made available to the court. Stop. Learned advocate representing the added respondent seeks time to revert with instruction. Stop. Released 27th. Should I direct the head of the
no, my lord, I shall come with my lord all the documents. That day, my lord, the document will be in before your lordship.
My lord.
Call 29 once.
My lord.
I'm appealing for the state.
my lord, I am praying for a note today.
On behalf of
my senior Mr. Firdaus Samimsi, he is engaged in Supreme Court today.
The last line should have been taken care of. This is not the way to seek adjournments. I make it not today.
My lord, can it be taken up, my lord, on Thursday, my lord?
Thursday?
Tomorrow, my lord, I have some fixed matters.
আচ্ছা ঠিক আছে থার্সডে লিস্টের নিচে লিখে দেবেন থার্সডে লিস্টের নিচে থার্সডে লিখে দেবেন
I'm deeply of that.
30
And for the petitioner, my lord, in last occasion, state was directed to come with the detail of vacancy.
where is the state
I have remind our phone also, my lord.